This morning, we will be hearing the case between Katrina Nisha versus Ahmad Construction Sindrian Berhad. The applicant of this case would be Katrina Nisha, the client, and the respondent would be Ahmad Construction Sindrian Berhad. Katrina Nisha will be represented by Nadira from Isam and Corporation Law Firm, while Ahmad Construction Sindrian Berhad will be represented by Nur Maisara Izzati from Hamaijuri and Corporation Law Firm. The issue, whether the respondent can claim the money work done and whether the contract would become voidable. Facts. The applicant had set a standard form of contract that the respondent needed to follow in order to proceed with the construction of the applicant's project. But the respondent did not follow the specifications stated in the standard form of contract, resulting in no price and delivery dates agreed between the two parties. This then led to the delay of the project. Furthermore, the respondent claimed for payment of work done, but the applicant counterclaimed for late completion of the works by the respondent. Assalamualaikum and good morning, ladies and gentlemen. I am Nur Ashura Alimin, who is in the chair of the arbitrator for today's proceeding season. My decision is legally binding and both as per the agreement. Now that I have read the relevant evidence in this matter, and hearing will be in order. This is a hearing in the matter of arbitration of a dispute between the applicant, Katrina Nisha, and the respondent, Ahmad Construction Sindrian Berhad. The order of these proceedings is as follows. Applicants will be allowed to make submissions followed by the respondent. I would therefore like to hear the argument from the applicant first whenever you are ready.
Thank you, Madam Arbitrator. My name is Nadira, and I am a lawyer from Isam and Corporation Law Firm in Kochi, and I will be representing Madam Katrina Nisha to claim for delayed completion of the work.
Thank you, Madam Arbitrator. My name is Katrina Nisha, and I am the employer of this case, and I'm here to claim for net completion of the works by the contractor for this arbitration.
If I may hear the submission of the respondent.
Thank you, Madam Arbitrator. My name is Nur Maisara Izzati from Hamaijuri and Corporation Law Firm. Will be here as the lawyer for the respondent, Madam Nur Izzati from Ahmad Construction Sindrian Berhad.
Hello everyone, my name is Nur Izzati and I am the respondent of the case. I am here today to present myself to you as a representative of Ahmad Construction Sindrian Berhad. I would like to express my gratitude for the chance to speak about my perspective and provide the viewpoint that I believe will throw light on the issue that is currently being discussed.
We will now hear the opening statement from the applicant.
Madam Arbitrator, unless anyone mind, we would like to begin. First and foremost, it is a claimant case that the respondent has met a voidable contract of extending the house. My client here, Madam Katrina Nisha, has signed an agreement with the respondent on 28 September 2023 to extend the house, which is located in Kochi, for the total amount of 40,000.
Applicant, can you explain why you say that the void contract happened between both parties?
Sure, Madam Arbitrator. As we all know, the contract can be voidable if there is cautions from one party to another party. After a month of signing the agreement, the respondent suddenly claimed for their work, which is more than what has been stated in the agreement. In the agreement, the extension should be 5 meters, but the respondent extended more than what it should, which is additional 3 meters in the extension. So, it is clear that this contract can be voidable. Therefore, in this case, this case can be referred under the sections 56 of Contract Act 1950. If a party to a contract failed to perform as agreed, the contract becomes voidable at the options of the promisee, if the intentions of the party was that time should be of the essence of the contract. This means that the party who did not agree with the contract may be in breach of the agreement, and the other party may have the options to void the contract and seek for compensations for any loss suffered as a result of the breach. I want you to explain why did you suddenly extend more than what you should without my client consent?
Respondents, what is your defense against the applicants?
Madam Arbitrator, the reason for the extension to happen is because decided to add another 3 meters to fulfill the overall floor area. So, because of the situation, my client deserves to claim for quantum merit. Based on the ground floor, a contractor can claim his work done based on quantum merit, which means as much as he deserves. This principle is recognized under Section 70 of the Contracts Act 1950. Section 70 of the Contract Act 1950 states that when a person lawfully does anything for another person or delivers anything to him, not intending to do so gratuitously, and the other person enjoys the benefit thereof, the latter is bound to compensate the former in respect of the thing so done or delivered. In the context of my client's situation, she has completed the work as per terms agreed in the contract, but the plaintiff fails to pay the amount of work done. My client could claim a reasonable amount of money based on the work that she had done, even if it exceeds the floor area agreed by the plaintiff.
Applicants, can you provide evidence to support the claim?
Madam Arbitrator, take a look at this agreement. Based on this agreement, the extension should be only 5 meters, but the defendant extended more than what has been stated in the agreement. Besides, the defendant copied the work more than the specified time. Section 40 of the Contract Act 1950 statement is that when a party promises to do certain things at or before a specified time and failed to do so, the promisee is entitled to compensations for any loss occasioned by the failure, provided the time was intended to be of the essence of the contract. So, in this case, the defendant completed the work more than the specified time, but still claimed for the quantum merit. The defendant can claim the quantum merit as they did not complete the work in the specified time.
How do you defend yourself, respondent?
Allow me to explain myself. The reason of lack of completion was because of late deposit payment from my employer. This has led to lack of material delivery, and this directly caused to lack of completion as well.
Madam Arbitrator, the reason for the late completion of the work done by my client is based on the delay in the deposit payment. The purpose of getting this deposit is to pay for the materials. The plaintiff failed to pay a total amount of 10,000 ringgit for the deposit for my client's work. My client had claimed for the deposit amount before starting her work, but the plaintiff failed to do so. The reason for her to claim the deposit payment before starting the work is because of wanting to purchase the material needed for the work that she will do. This was stated orally and agreed by both parties. As you can see by law, legal agreement could be in the form of writing and oral, based on the Contract Act 1950, Section 10, Bracket 1, stated that all agreements are contracts if they are made by the free consent of parties competent to contract for a lawful consideration and with a lawful object, and are not expressly declared to be void at this moment. When the plaintiff agrees to pay the deposit amount, it is considered as a contract even though verbally.
I'm sorry, but as far as I know, there was no agreement for deposit payment in the first place.
Can you explain further on these applicants?
Madam Arbitrator, from the agreement that I have shown you before, there is no deposit included in the contract. However, they still claim for the deposit. In this case, there is no agreement for the deposit at all, but the defendant claimed that she had an agreement already with my client.
Allow me some time to make a decision for this dispute. On going through the evidences, I came into conclusion that the applicant has not asked for any additional work made to the respondent property. The respondent claimed for quantum merit from the applicant. The respondent has been threatened not to be paid as her work is done late. There is no agreement regarding deposit between applicant and respondent. Having carefully considered the evidence and arguments, it is clear that the defendant has voided the contract as they did not follow the specification in the agreement based on Contract Act 1950, Section 56. Besides, the defendant completes the work more than the specified time, which leads to the late completion. In conclusion, the defendant cannot claim anything from the applicant as they have voided the contract. That's all.